Morning everyone. What we'll do is, I know that people will have to leave probably a little before 9, so I'll attempt to push through in the best part of 20 minutes, and then perhaps we might have a couple of minutes for questions at the end. In this part of the presentation, we're going to be looking at liquidated or agreed damages clauses and the circumstances in which they might constitute a penalty. Now, of course, it's common to use liquidated damages clauses in contracts as a means for increasing contractual certainty and providing in advance what the consequences of breach will be. But any time that you use an agreed damages or a liquidated damages clause, of course, you run the risk that it might be said to constitute a penalty. And if that's the case, it won't be enforceable. So what we're going to do today is to look at the Doctrine of Penalties and the principles that apply in determining whether a liquidated damages clause is a penalty. We're then going to look at some of the recent developments in the Equitable Doctrine of Penalties, which have arisen in the context of class actions challenging bank fees. We're then going to look at a couple of recent applications of the Doctrine of Penalties in the commercial context, and you'll notice that I've actually got a written paper included in there, so in the interests of time, I might just look at one of those cases and leave you to read the others. And finally, we're going to look at the application of the Doctrine of Penalties in a specific context, which is agreements to settle litigation, because there's a body of case law that's grown up in relation to that. So I thought we'd just start by looking at the definition of liquidated damages. You can see one that's been provided there by the Victorian Court of Appeal. Essentially, a liquidated damages clause is a clause that attempts to set out in advance what a defaulting party will need to pay in the event of breach. And that might be by providing for a lump sum payment, or it might set out some mechanism by which that payment is to be calculated, or some sort of scale of costs. Now, the distinction between an agreed or liquidated damages clause, which is valid, and a penalty which is unenforceable, was first established or enunciated by Lord Dunedin in Dunlop Pneumatic Tyre Co. and New Garage and Motor Co. Not first established, but that's the seminal case in the area. And Lord Dunedin distinguished between a liquidated damages clause on one hand, which is a genuine pre-estimate of the loss that a party is likely to suffer in the event of breach, and that's valid, and on the other hand, a penalty, which is not a genuine pre-estimate of loss. It is in fact either an inducement or in fact a punishment for the other party for not complying, and that will be unenforceable. So the way that he described it was the essence of a penalty is a payment of money stipulated as in terrorem, or in other words, to put the breaching party in fear to make them comply with the contract. And whether or not a liquidated damages clause is in fact a penalty is a question of construction based on the terms and the circumstances of the contract, and judged at the time of entry into the contract, not at the time that the breach occurs. And Lord Dunedin set out some general principles for working out whether or not an agreed damages clause is in fact a penalty. Now, if the amount that the breaching party has to pay is extravagant and unconscionable, by reference to the greatest conceivable loss that the innocent party might suffer, then that will be a penalty. And building on that, if the contractual obligation is to pay a sum of money, and the agreed damages clause provides that if that sum of money is not paid, a greater sum must be paid, then that will constitute a penalty. And Lord Dunedin also said that there is a presumption if an agreed damages clause provides for a certain payment to be made in the event of a range of breaches, and some of those breaches are serious and some are trivial, then there is a presumption that that provision is a penalty. And Lord Dunedin also said that in some cases it's actually not possible to precisely calculate in advance what loss will be suffered in the event of breach. And that's exactly the kind of case where a liquidated damages clause is likely to be valid, because it's simply not possible for the parties to estimate in advance the loss that the innocent party will suffer. Now, that doctrine was applied by the High Court in Ringrow and BP Australia. Now, in that case, Ringrow, many of you are probably familiar with this case, Ringrow purchased a service station from BP, and the agreement provided that if Ringrow were to breach the agreement, then BP, as well as getting liquidated damages, could exercise a right of repurchase of the service station. And if it did that, BP was required to pay Ringrow market value less the value of any goodwill in the business. And Ringrow, having breached the contract and BP attempting to exercise that right of repurchase, Ringrow argued that that was a penalty because it was being deprived of the value of goodwill in the business. Now, ultimately, Ringrow failed in all three courts because it had failed to adduce any evidence that there was, in fact, any goodwill in the business. So it wasn't possible on an evidentiary basis to say that what BP was going to get in exercising its right of repurchase was extravagant and unconscionable in relation to the loss that it would otherwise suffer by virtue of the breach. And the High Court also rejected the argument that there was a proportionality requirement. They said it's not necessary to show that what the innocent party will get in the event of breach is proportionate to the loss that it will suffer. But the court can take proportionality into consideration. And if what the innocent party will get is out of all proportion to its loss or significantly greater, then that will constitute or is likely to constitute a penalty. Now, the doctrine of penalties has been recently developed. The Equitable Doctrine of Penalties has been recently developed in the High Court case of Andrews and ANZ, and many of you again will be familiar with this case. And it involved a class action challenge to bank fees that were payable by customers in the nature of late fees, honour, dishonour fees, over-limit fees and so on. Now, the important point that comes out of Andrews and ANZ is that the Equitable Doctrine of Penalties continues to exist in parallel with the Doctrine of Penalties at common law. It had been argued by ANZ that the Equitable Doctrine no longer existed as a separate doctrine and it had been subsumed within the common law. But the High Court said that wasn't the case and the Equitable Doctrine continued to operate. Now, what's the significance of that? Well, at common law, the Doctrine of Penalties operates if you have a breach of contract. Whereas in equity, the Doctrine of Penalties doesn't require a breach of contract. What it requires is a stipulation that is collateral to a primary stipulation. Now, if you haven't read the case and you find that confusing, I'm not surprised because it's actually a very confusing concept. I've set out there what the High Court actually said in terms of collateral and primary stipulations. But perhaps for anyone who's not familiar with the case, I might explain it this way, by reference to late payment fees. Under a contract between a customer and a bank, there might be a contractual requirement to pay your credit card debt or a minimum repayment by a certain day, a contractual obligation. And the contract may provide that if you breach that condition, you have to pay a late fee of $25. Now, that's the traditional or common law application of the Doctrine of Penalties because the $25 late fee is payable on a breach of contract. But the way that the High Court explained it in ANZ was, it doesn't matter if you've got a contractual obligation to pay your credit card off by the due date. The contract may simply say, you don't have to pay your credit card off by the due date or pay the minimum repayment, but if you don't, we'll charge you a late fee of $25. And what the High Court said was that the Doctrine of Penalties still applies in that case, even though it's not a contractual breach not to pay the minimum repayment by the due date. What they said was that $25 late fee is a collateral stipulation to the primary stipulation of paying your minimum payment by the due date. And the Doctrine of Penalties is capable of operating in that situation. And the significance of that is that the Doctrine of Penalties now operates beyond the situation of breach of contract. You no longer need a breach of contract in order for the Doctrine of Penalties to come into operation. And that was illustrated further in the case of Cedar Meats and Five Star Lamb in the Court of Appeal here, which I'll talk about in a moment. And the idea of this was developed, or the High Court decision in Andrews was developed by Justice Gordon in Pakioko, or explained in Pakioko and ANZ, which was another case dealing with a challenge to bank fees. And in terms of actually understanding what the High Court said and how the Doctrine of Penalties operates, Her Honour's decision is very helpful. And basically, there was a further challenge to bank fees, and Her Honour found that late fees, that is late payment fees for not paying your credit card minimum repayment, did constitute a penalty. And there was evidence about the greatest conceivable loss that the bank would suffer if a person didn't pay their credit card payment on time. And the evidence was that that loss would range somewhere between 50 cents and about $3.50. By contrast, the late payment fee that a person had to pay if they didn't pay their credit card in time was something like $25 or $30, varied over time. And Her Honour said that that late payment fee of $25 or $30 was extravagant and unconscionable by reference to that lower level of the bank loss, and therefore late payment fees were a penalty. By contrast, other types of fees, honour and dishonour fees and over-limit fees, the Doctrine of Penalties didn't apply to them because they were actually an additional service or related to additional service provided outside the terms of the contract. If a person wanted to overdraw their account and they didn't have sufficient funds in there, then that was equivalent to making a request to ANZ to honour that by, for example, honouring the cheque or providing funds when there were insufficient funds in the account. And the fee that was payable, which was again in the order of $25 or $30, was in fact consideration provided by the customer to ANZ for considering that further request. So those fees fell into a different category and the Doctrine of Penalties didn't apply to them. As I said, in the interests of time, I'll restrict this section to just a discussion of the Victorian Court of Appeal case of Cedar Meats and Five Star Lamb. That was earlier this year. Now, in this case, there was a contract between Cedar Meats and Five Star Lamb for Five Star Lamb to provide certain quantities of lamb to Cedar Meats for processing. And the agreement provided that Five Star Lamb would provide certain daily minimum quantities of lamb, and if they didn't, then they still had to pay Cedar, if they fell below 25% or more below that minimum daily quantity, they still had to pay Cedar Meats 75% of the fee for the minimum daily quantity. Now, throughout the duration of the contract, Five Star Lamb never met that minimum daily quantity. They were struggling a fair bit and only ever gave Cedar Meats small quantities of lamb for processing. Now, Cedar Meats never enforced that requirement that they pay 75% if they fell short, but eventually the contract terminated and Five Star Lamb decided it was going to go with another abattoir. And at that point, Cedar Meats decided to enforce the arrangement and to claim against Five Star Lamb for effectively the amounts that were owing in arrears for failing to meet that minimum daily quantity. And Five Star Lamb challenged that on the basis that that was a penalty. And the Court of Appeal found that, agreed with the trial judge that in fact it was a penalty. And they considered, first of all, whether there was actually a contractual obligation on Five Star lamb to meet that minimum daily quantity. And they said, well, in their view, it wasn't a contractual requirement, but even if it wasn't, it still fell within that collateral stipulation, primary stipulation that was set out by the High Court in Andrews and ANZ. So whether there was a contractual obligation or not, the doctrine of penalties still applied. So there we see that equitable doctrine of penalties from Andrews and ANZ, the implication that that has in this context. And the trial judge's finding that, in fact, that amount of 75% was extravagant and unconscionable by reference to Cedar Meat's greatest conceivable loss, that wasn't challenged on appeal. So the Court of Appeal didn't need to consider that. And the evidence was that Cedar Meat's loss was in the vicinity of, I think it was between 28 and 40% of the minimum daily quantity if Five Star lamb didn't meet that. So by reference to that, having to pay 75% of the fee for the minimum daily quantity, the trial judge had found was extravagant and unconscionable. But the Court of Appeal did give a note of caution, and what they said was, you have to be careful about looking at this kind of situation where the parties are of equal bargaining power and they've struck this agreement for this payment of the 75%. And in saying that that's a penalty, you have to exercise some caution. So the relationship between the parties is a relevant factor. And indeed, in Pakioko and ANZ, Justice Gordon referred to that in finding that the late payment fees for the credit card were a penalty. She took into account the fact that the agreement was between a bank customer and the bank. It was a standard form contract. The customer didn't have any input into the drafting of the contract. And she said that that was a relevant factor in determining that it was a penalty. So it's always important to keep in mind, again, that the context of the contract can be of significance in determining whether a clause like this is in fact a penalty. What I'll do now is I'll just skip over Elberg and Fravel and Pioneer Energy Holdings. As I say, I've outlined the facts of those in the written paper and you can have a look at those. And I'll move on to have a look at penalties in the context of settlement. Now, this is the particular instance or example of where this applies is when parties to litigation settle prior to trial, and as a condition of the agreement, they say, well, amount X is the amount that's owing, or amount X is what the plaintiff has claimed. But we agree to settle on the basis that the defendant will pay a smaller amount Y. And there are certain conditions usually imposed on that in terms of time to pay, payment of instalments and so on. And then the agreement will say, if the defendant defaults on that and doesn't pay those instalments or doesn't pay them by the due date or whatever, then the plaintiff will be entitled to enforce judgment for the fuller amount. Now, that type of clause in a settlement agreement has been challenged a number of times on the basis that it constitutes a penalty, because that higher amount is extravagant or unconscionable in relation to the amount Y that's provided for in the settlement agreement. And what the courts have said basically is that you need to look at whether or not there has been an acknowledgement of liability by the parties. Is there an acknowledgement that that higher amount X that was claimed by the plaintiff, that is a debt due and owing? Is there an acknowledgement of liability in relation to that amount? Because if there is, the doctrine of penalties doesn't apply. And that's because the courts have said a creditor who is owed X amount of money is entitled to strike a bargain with the other person that they can satisfy that debt by paying a smaller amount on certain conditions. But if those conditions aren't met, then the full amount, X, is a debt due and owing, and the doctrine of penalties doesn't apply in that situation. So this is illustrated by the Victorian Court of Appeal decision in Cameron and UBS. And in that case, Cameron had had a judgment awarded against him in a Swiss court in the amount of 8.4 million Australian dollars. And the plaintiff sought to enforce that in a Victorian court. So there was no issue as to liability because that had already been determined in a foreign court. The only issue was whether or not the judgment could be enforced in Victoria. And the parties agreed to settle on the basis that Cameron would pay $1 million in satisfaction of the debt in 5 instalments of $200,000. And he defaulted. I think the 3rd, 4th and 5th payments were paid late. And the plaintiff sought to enforce the judgment, to reinstitute proceedings, and sought the full payment of $8.4 million, less what had been paid by Cameron, and also its costs. And it was successful in that on the basis that the court said the parties had acknowledged liability for that greater amount owing. There was no dispute between them as to liability. That had already been decided by another court. This was simply a case where the plaintiff had agreed to strike a bargain with the defendant, that the defendant could pay a smaller amount of money in satisfaction, but when the defendant defaulted on that, the full amount became due and owing. And again, I won't go all through these cases. They're all mentioned in the written paper. The case that is different and that is sometimes cited by reference to or against Cameron is the Queensland Court of Appeal case in Zenith Engineering. And similarly, the parties there agreed to settle. The claim was for $72,000. The parties agreed to settle by the defendant paying a smaller amount of $55,000, which was referred to as being in full settlement of the plaintiff's claim. And when the defendant defaulted, the plaintiff sought to enforce judgment in the amount of $72,000. And the court said, the Queensland Court of Appeal said, that was a penalty. Now, that case has been considered by a number of subsequent decisions, and generally it's been distinguished from cases like Cameron and the case of CalCorp, which is also referred to in my paper, on the basis that in Zenith there was no acknowledgement of liability. The court looked at the wording of the agreement, and they said, by contrast to some other cases where that amount X is referred to as the judgment debt or the agreed sum, in this case, the parties had just referred to that amount as the plaintiff's claim. And that indicated that it wasn't something that had been agreed as a liability. It was just the amount that the plaintiff was claiming. So what all of this indicates in the context of a settlement agreement is that the words used in the agreement and the background to the agreement can be quite significant. And of course, it may be that words like agreed sum or judgment debt are used without perhaps being aware of the cases that have considered these things, but just the simple use of those words like the amount the plaintiff claims or the judgment debt or agreed sum can actually have significance in determining whether or not the court finds that that amount is a debt due and owing. Because if it is a debt due and owing, the Doctrine of Penalties doesn't apply. But if in fact there is no agreement between the parties and the issues are still live between them, then the Doctrine of Penalties does apply, and the court will consider whether that greater sum is extravagant and unconscionable by reference to the smaller sum that the defendant has to pay under the agreement. It's 5 to 9 now, so I'll leave it there. I'm not sure if anybody has any questions, but if you do in relation to my part of the presentation, please do feel free to give me a call or send me an email if you'd like to discuss.
Ladies and gentlemen, we won't delay with questions now, but thank you for joining us for this Greens List breakfast briefing, and please join with me in thanking both Kylie and Alan.